Sorry, Your Honor, I saw you on the bench and I kept walking by and thinking it was.
That's all right. All right, we're here on case 2023-300352, State of Florida versus Ellen Gilland. Ms. Gilland is present with her counsel, and State is present also. We're here initially. I know you have some additional proceedings scheduled before Judge Weston shortly. We're here initially to address just the status of the case. Obviously, this case is set for trial date certain in January, and what I wanted to do before you start the evidentiary issues that are going to occur later this afternoon is to have a discussion about what, if any, plea offers have been exchanged or made, and make sure Ms. Gilland understands the exposure she's facing at this point. So, Mr. Interlicchio, first at this point, has the state made a plea offer in this case?
I don't know if there was one. I'm not sure if Mr. Gomez had made one prior to my arrival, but there's not one now.
All right, and have been, counsel, have there been any plea discussions that have occurred in efforts to resolve the case short of trial?
Ms. Gunn, I know communication has been provided to the state. It doesn't appear, I guess, that because they're not willing to consider that communication for purposes of plea discussions.
All right, Mr. Interlicchio, is the state intending to make any plea offers at this point?
No, Your Honor.
So, at this juncture, Ms. Gilland, you are facing the following four charges for which you've been indicted: assisting self-murder, manslaughter, allegation that you assisted in the self-murder or manslaughter of Jerry Gilland, and in the commission of that shot a firearm. In addition, you were indicted for 3 other offenses: 2 counts of aggravated assault with a firearm, and then the final 4th count of aggravated assault of a law enforcement officer with a firearm. The 2 counts of aggravated assault with a firearm are each 3rd-degree felonies. Each offense carries a 5-year potential penalty. The aggravated assault on a law enforcement officer is a 2nd-degree felony punishable by 15 years, subject to a 3-year minimum mandatory because of the allegation that a firearm was used. And then finally, the most serious offense, of course, is the assisted self-murder or manslaughter charge, which is charged as a 1st-degree felony. State, with the allegation of the firearm, does that remain that was the enhancer that made it a 1st-degree felony?
That is correct, Your Honor.
Manslaughter would otherwise be a 2nd-degree felony. The allegation of the firearm enhances it to 1st-degree, which is a 30-year exposure. So the total exposure you face would be 55 years in prison. Do you understand that, ma'am?
I understand.
And have you, without telling me your discussions with your lawyer, have you had discussions with your lawyer about efforts to otherwise resolve this, or attempts to otherwise resolve this case short of a trial? Don't tell me what you talked about. I just want to know if you and your lawyer have talked about options or other attempts to try to resolve this matter short of a trial.
Yes.
And do you believe you've had adequate time to explore that with your counsel?
Yes.
And, sir, have you, do you believe you have exhausted those efforts on behalf of your client with both with her and the state at this point?
In all due respect, I don't think she has any options.
Yeah, well, I understand that. I understand the exposure, given her age, should she be convicted. It's a significant sentence that she'd be exposed to.
Yes.
All right, and state, is there any likelihood the state would engage in any negotiations at this juncture?
I mean, we're always open to hearing potential plea offers or anything of that nature, but we haven't been presented with any.
All right, are you intending to present a specific plea offer to the state for them to consider?
I'd be more than happy to provide them with a resolution that would possibly resolve the case, but I think they know what the ultimate goal as it relates to Ms. Gilland is.
So the posture, as I understand it at this point, is that the state has not made an offer, but they would, I hate to use the word entertain, but they would listen to any potential resolution and then determine if that was something acceptable. Is that, am I
Yes, Your Honor.
summarizing that correctly, Mr. Interlocuio?
Yes.
So is that something you're intending to do?
I'll be more than happy to, Your Honor.
Well, I would encourage you all to engage in those discussions at this point. Your window of opportunity is closing because of the upcoming trial date. I certainly don't have the ability to speak, nor would I speak for the state to know whether that's something they would agree to or not. Ms. Gilland, obviously the other option for you is you can enter an open plea to the court, but you understand by discussions with your counsel and what I just stated on the record, there's a great exposure. So without any kind of agreement by the state that there would be a narrowing window of exposure there, obviously there would be no guarantee of any particular sentence. Do you understand that?
I understand.
Right, so do you, at this juncture, counsel, do you want an opportunity to speak to Mr. Interlocuio about a specific potential resolution for him to determine if that's something that the state is willing to consider?
Sure, Your Honor.
All right, we'll give you that opportunity to do so outside the presence of the court. So I'll be in recess.
So we're still doing your evening, or you want to? Okay. I am West.
Welcome back to work. Love your music.
All right, counsel, have you had an opportunity to have those discussions?
Yes, Your Honor.
And Mr. Interlicchio, is that based on those discussions, are there going to be ongoing discussions, or procedurally, where are we at this point?
We're discussing things. There's going to be, I think the discussions will be a little bit ongoing, but we'll have an answer pretty shortly.
All right, counsel approach. All right, based on the discussions that you all have had, then at this point, we'll just proceed further. Ms. Gilland, obviously your counsel will keep you updated on what those discussions are. Those are private negotiations. They do not involve the court. So we'll see if anything results based on those discussions. At this point, there is a motion in limine that is scheduled to be heard by Judge Weston, who will be trying the case, and I'll take a brief recess to get Judge Weston in here, and then you all can proceed on those matters. and obviously update the court if there is any potential resolution based on those discussions that are now occurring.
Thank you, Judge.
You're welcome.
So thank you all for speaking with Judge Blackburn briefly about the potential for resolution of this case. Even if the parties are far apart, I think that's always helpful for you to have those discussions. So we're here on the state's motion in limine, is that right?
Yes, Your Honor.
Okay.
And Your Honor, the state's filed a motion in limine in response to the defense's witness list, and we're seeking to exclude the testimony of Dr. Jeffrey Danziger, Crystal Brown, registered nurse, and limitations as to Dr. Stephen Nelson's testimony and Dr. I'm going to butcher his name, Nagarajan. And what we're seeking is, the first is they're trying to introduce Dr. Danziger, which the court I know is familiar with Dr. Danziger. And in this case, this is not a insanity defense. They've not filed a not guilty by reason of insanity, so her mental status doesn't play any role in this case.
Is the evidence about the defendant's mental status or about the decedent's mental status?
It's going to be a little bit about both, but again, even if it's the victim's mental status, how would somebody who's never spoken to somebody be able to testify as to their mental state? That doesn't seem to comport with anything. So they're seeking to introduce those two witnesses. Dr. Stephen Nelson, they want to have him testify as to pain and suffering, but pain and suffering has absolutely no relevance in this case. There's no bearing on that. In their response, they basically stated that this is to prove that the victim in this case had the intent to commit suicide, but that's what the state's already alleging in manslaughter, self-assisted suicide. That's what we're already saying. He wanted to kill himself. Because of his pain or suffering or whatever reason he chose to kill himself is irrelevant, and it's only to elicit sympathy for the defendant in this case that she's caring for this individual that supposedly was in so much pain and suffering. That's why we're seeking to eliminate it. It doesn't have any relevance. It doesn't tend to prove or disprove any material element in this case, and that's the issue with why they're calling these witnesses, is they don't tend to prove or disprove any material element in this case. They're only being elicited for the sympathy factor, and that's impermissible under the rules of evidence.
All right, thank you. Mr. Ferry.
Judge, the state has filed a motion to exclude Dr. Jeffrey Danziger, who is a forensic psychiatrist. He's also, according to his report that he's filed with the court, he also is board certified in geriatrics, which is obviously the care of the elderly. Dr. Stephen Nelson is another defense witness. He's the chief medical examiner in Polk County. We've asked for the testimony of Crystal Brown. She was the treating nurse for Mr. Gilland, and also the doctor who treated Mr. Gilland. The testimony of Dr. Danziger is necessary for a variety of reasons. One is to show the relationship between Ms. Gilland and her late husband, Jerry Gilland. Ms. Gilland and Jerry Gilland were happily married for 53 years. Prior to his hospitalization, they resided together. Dr. Danziger testifies relates to Mr. Gilland's mental state, and so in response to the state, Dr. Danziger, who has not been deposed by the state, has reviewed Jerry Gilland's medical records and can testify as it relates to those records based upon his expertise. He could also testify as it relates to Ms. Gilland's lack of purpose or intent to deliberately seek or want to voluntarily and intentionally end her husband's life. That's one of the elements as it relates to assisted self-murder, specifically element 2 and element 3 of assisted self-murder under Florida statute 7208. So his testimony is more than meets the relevant standard under 9404. Dr. Stephen Nelson, his testimony is relevant and admissible as it relates to Mr. Gilland's history of hospitalization. It relates to our theory of defense that Mr. Gilland committed suicide. His testimony regarding Jerry Gilland's level of pain, the quality of life, the living conditions are all relevant and support a theory of our defense. Crystal Brown, the treating nurse,
Let me interrupt you there and ask a question about that. It's a theory of the defense that Mr. Gilland wanted to commit suicide?
Yes, Your Honor. I mean, element 2 of standard instruction 7.7c, assisted self-murder, element 2, the state must establish that it's an offense to the charge that Jerry Gilland killed himself. And so...
But it's also an element of the crime, so I'm not understanding how it's a defense.
Well, so the way it's charged in the indictment, it's very confusing. And so it's a defense to manslaughter, as the state has alleged it in the indictment, and it's an element of the charge in assisted self-murder. So in any event, it's relevant in the case because they have to prove that element, right, under assisted self-murder, or it's a defense in the other case. So under any theory, for the court's purposes, is relevant. So Crystal Brown's testimony is obviously relevant and admissible to again our theory of defense. She was the treating nurse for Mr. Gilland. He expressed to her numerous times throughout his stay that he wanted to kill himself. And so obviously her testimony is relevant. She also could testify that he was a 77-year-old male with a documented history, psychiatric history, multiple organ failures. He required a trach be placed in his throat because he was unable to breathe. So she could testify as it relates to his major depressive disorder. She could also testify as it relates to Ms. Gilland's continued care for her late husband. She was there with him throughout the day. She had to require and paid out of pocket for staff to be there at night to ensure his safety because he was trying to kill himself. And so that testimony is obviously relevant and admissible as relates to count 1 of the indictment. The state also has elected to charge her with additional counts 2, 3, and 4, aggravated assault. Obviously, I think this testimony as relates to Dr. Danziger, his assessment of Ms. Gilland is relevant and admissible under those elements of aggravated assault. And so I also provided the court with the Chambers decision. That's a U.S. Supreme Court case from 1973 as relates to Ms. Gilland having the fundamental right to present defenses. The other case I think is close to Ms. Gilland's case is a decision in VANNIER versus State. It's a 4th District Court of Appeal decision. It was a homicide case, and the court held that the victim's suicidal intent, as well as evidence that the victim had been given prescription medication and the side effects of those medications, which include depression, aggression, and suicide, that it was an error for the trial court to not permit that testimony. I think that closely resembles this matter. And so we're asking for the court to deny the state's motion in limine and permit the testimony from these witnesses.
All right, thank you. I may have some other questions. I have a couple questions for Mr. Interlicchio.
Sure.
So I agree with what Mr. Ferry's saying about the indictment being a bit confusing in the language. It's alleging intent, an intentional killing in part, in addition to the elements of assisted self-murder. So what's the state's theory?
So the manslaughter as it is charged as manslaughter culpable negligence and as well as the self-assisted suicide. So as far as intent is concerned, intent is always an operation of the mind, and it is also a question for the jurors. That's the ultimate province of the jurors. Having an expert come in here and testify as to what another individual's intent would be is invading the province of the jury. And it's also saying that the jurors, based upon the facts that are presented at trial, would be unable to determine what her intent would be.
Right, so I want to go back to the jury instructions.
Sure.
We kind of skipped over that. Not skipped over it, but I'd like to address that a little bit further. So are you not proceeding under the 7.7C jury instruction, or is there an additional one that you're going to be proposing?
No, we're proceeding under the it would go under the assisted self-murder, but it would also have the manslaughter culpable negligence as well, would be another jury instruction.
Okay, so what is the additional jury instruction you're going to be seeking?
Pull up the standard instruction for manslaughter culpable negligence, Your Honor. That's going to be... That's just simply 7.7. And all I have to prove is the victim is dead and that the defendant, and you just have to prove to A, B, or C, depending on the facts, intentionally committed an act or acts that caused the death of the victim, intentionally procured an act that caused the death of the victim, or the death was caused by the culpable negligence of the victim. Of the defendant. So I can take any of those 3 that would apply in this case. And those all would fit within the facts of this case. Again, even though Dr. Danziger may want to attempt to describe what her intent is a jury question. He's invading the province of the jury, and there's nothing specialized or anything here that the jury would not be able to understand what her intent is. And this is an individual who brought a gun to the hospital, loaded the firearm, purchased the ammunition, and fired the round that killed her husband. I don't see any issues where an expert is needed to explain what her intent would be that day. There's no specialized training or knowledge that would be outside the jury's own common sense to determine what her intent was.
Okay, so to the extent this state's proceeding under the manslaughter instruction and alleging that this was an intentional act by the defendant to cause the harm, then the suicidal tendencies are absolutely relevant to her defenses. I'm going to let that come in. It's not going to become any kind of focus of the trial, but she's entitled to introduce that. And again, that's the state's own choosing to proceed under both of these kind of contrary theories. So that's what makes it relevant.
Well, they're both intentional acts. I mean, culpable negligence is intentionally committing an act or act that caused the death. So pulling the trigger is killing him. That's an intentional act.
Yeah, I'm aware of that.
But
Thanks.
intentionally providing a weapon and shooting him and assisting in his suicide, again, is an intentional act. What about her intent is outside the purview of a jury where an expert would need to be needed to explain what her intentions and thoughts were.
Well, it's arguably inconsistent to say, on the one hand, that the victim committed self-murder, and two, that the defendant intentionally committed something that caused the death. I think those are internally inconsistent, but maybe nobody else does. Maybe it's just me, but that's why I'm allowing that to come in about committing self-murder. Was that his plan? Was there a reason for it? I'm going to let a little bit of that come in so that the jury can evaluate whether it was a self-murder or it caused exclusively by an act of the defendant.
So what exactly then would Dr. Danziger testify to as to the thought process of Mr. Gilland when he's never spoken to Mr. Gilland, interviewed Mr. Gilland at all? He can look at a medical record and say, on one day he decided he wanted to kill himself, on another day he wanted to go home and said he was looking forward to going home. So what does Dr. Danziger add to this? That's what I'm missing here from the court is.
No, I understand, and we can go through that. Your 5-paragraph motion didn't really tell me much about what Dr. Danziger might testify to, and the response didn't either, and nobody's giving me a transcript of a depo, so I'm a bit in the dark as to what the extent of it would be, but the response tells me he's going to testify about the relationship. That's not relevant. A 53-year happily married couple, that's not relevant. Residing together, I mean, that's probably relevant. Lack of purpose or intent, I don't think is within the purview of something that the doctor can testify to. But I really wish I had depo transcripts. Have they been ordered?
No, we did not depose Dr. Danziger.
Oh, okay. All right, I mean, I can rule based on what little information I have. I'm going to exclude Dr. Danziger's testimony, except to the extent he would testify they resided together in New Smyrna prior to the hospitalization.
As it relates to Mr. Gilland's mental state, is the court going to allow Dr. Danziger to testify as it relates to his review of the medical records in Mr. Gilland's mental state?
What's your thoughts on that, Mr. Nolicchio? Is it that that's not relevant?
That he at one point said he wanted to commit suicide. I think there's the O'Neill v. State. It's 372. I didn't bring a copy of the case with me. Southern 3rd, 733. And this is an individual who tried to claim PTSD when he committed a murder. But in it, they basically the state crossed and said, hey, you've never even spoken to this defendant. You've never done any examination. The only thing you have is you looked at some records and said that's it. That's all he has in this case. He can't formulate an opinion as to whether or not an individual wanted to kill himself based on scant medical records. I don't think that that's enough for an expert to come in and opine, oh, absolutely, this guy wanted to kill himself when, you know, he's got one notation of wanting to kill himself in his medical records.
Okay. Do you want to reply?
That's the purpose of cross-examination. I mean, he can cross-examine Dr. Danziger as it relates to his testimony.
Yeah, I agree he could cross-examine the doctor, but I don't think that is sufficient basis for Dr. Danziger to provide an expert opinion based on a review of medical records as to someone's intent or state of mind or anything like that. I don't think that's appropriate. So that will not come in. So the next one we can address, I guess, is Crystal Brown, and she was the nurse, correct?
Yes, sir.
Providing treatment. I think that the decedent's pain in terms of statements that he may have made to her, expressed to her. I think that that is relevant, and that goes to the second factor for assisted self-murder. I think that that will come in, but again, it's not going to be any kind of focus of the trial, but I can't stop the defendant from providing their defense, basically, to the manslaughter charge. Just looking to see if there was anything else in here. She could testify that Mr. Gilland required a tracheostomy. He couldn't breathe on his own. I think she could testify as well about a diagnosis of major depressive disorder that was recurrent and severe. And she can testify, of course, about what she saw, that Ms. Gilland was there at the hospital as well. All right, and then the next witness, Dr. Nelson, the chief medical examiner for the 10th. And so the response says that he was planning to testify about Mr. Gilland's level of pain, quality of life, and living conditions to support the theory that the decedent wanted to commit suicide. Again, this sounds a bit repetitive to what Crystal Brown is going to testify to, and I'm not sure that Dr. Nelson really has any this doesn't strike me as an expert subject of testimony if it's just based on medical records. What's your thought on that one, Mr. Narlicchio?
It's also, I don't think that Dr. Nelson is there to talk about what pain, what quality of life he had and living conditions. Even our own medical examiner said that's outside her wheelhouse. That's not what a forensic pathologist can do. She can't testify. That would be proper for his clinician. Secondly, pain, quality of life, I'm not sure that's, again, like I said, it's not within his wheelhouse of things to talk about and why that would support his theory of suicide. I mean, we're already alleging the victim wanted to kill himself, so there's not really anything there other than to just kind of add and pad sympathy towards the defendant in this case, saying that she's taking care of this allegedly Mr. Gilland's suffering tremendous amounts of pain, and he had this really poor quality of life and living conditions. I think that's just trying to add sympathy into this case where it's not really applicable as it relates to these charges.
Okay, Mr. Fair?
I took the deposition of the state's medical examiner. The state's medical examiner, just like Dr. Nelson, reviewed Mr. Gilland's entire medical file. And our expert strongly disagrees with the state's medical examiner. And he testified, well, the state didn't oppose him, so but I can articulate Dr. Nelson, when reviewing the medical records, indicated that Mr. Gilland was in an exorbitant amount of pain, suffering, had expressed numerous times to medical staff to wanted to end his life. And so his testimony is relevant to the assisted self-murder element 2, element 3, and it's going to contradict the state's medical examiner testimony at trial. Because they're going to want to say, the first thing they're going to want to say from the medical examiner, oh, Mr. Gilland, his health was improving. He was getting better. And then Ms. Gilland took some act that prevented that. And I'm not going to have any witnesses to rebut what the state says about my client.
Okay, what's your response?
Whether he was in pain and suffering doesn't matter. It's whether or not he wanted to kill himself. We're agreeing he wanted to kill himself. The jury may not, why we have it charged in the alternatives, the jury may say, look, this suicide note, the pact that they kind of wrote up, it's a typewritten letter by the defendant, and it's signed by the defendant. There was talk in the notes of that he wanted to go home and he was looking forward to a better life. They may reject the fact that this was even a suicide. They may think she murdered him, and it could be the manslaughter, culpable negligence. That's up to the jury to decide those facts. I mean, they're the decision makers there. But saying pain, quality of life, and all those things, those are just maybe decisions why he might have wanted to kill himself, but that doesn't apply to whether or not he did commit self-murder.
Okay, I'm going to reserve on this one and see what testimony comes out from the state's witness at trial. But as to it, I'm not going to grant it today. And then the last individual is Dr. Ravi. How do you say his last name?
I feel bad butchering it. It's,
Well, I thought Mr. Ferry could offer to pronounce the name. He's a defense witness, correct?
No.
he's the state's witness.
Okay, so you're not asking to strike that witness, then you're just asking to limit the ability to get that testimony from the state's witness?
Yes.
Okay. All right, and then just looking in the response to see if it tells me, I don't see any specific reference to that document. So based on my prior ruling, I do think that it is relevant based on the state's arguments that the decedent was in pain, was suffering, and I'm not going to prohibit the defense from eliciting that testimony. Was there anything else raised in the motion, Mr. Interlocutor, that I need to address?
No, nothing further from the state.
Okay. And I think when we had talked previously about scheduling, I had mentioned picking a jury on the Friday preceding my trial week in January. I did not order jurors for that Friday, so we're going to have to start with jury selection on Monday, January the 6th at 8:30. And I have 50 jurors coming in that morning. Will we be able to get it done that week, do you all think?
I believe we'll be able to get it done. It won't be a lengthy trial. I think the issue is going to be just jury selection.
Yeah.
Do we have jurors coming in other than Monday, or can we pull more from Monday on this?
I actually have 90 jurors coming in on Monday because I'm going to have some other judges trying other cases for me. So we're going to have jurors available that afternoon as well that will be recycled. So we'll have a total of 90, but they are all coming in on Monday.
The only scheduled issue that I have, Judge, is when one of the state's analysts, the gun arrested analyst, is from out of state, and we have to make arrangements to bring her down, fly her down, testify in the trial. We're trying to get confirmation that she's available. So we haven't received that confirmation, but we need her to come. So.
Okay. So, I mean, I can't really give you any information about what day she'd be likely to testify, but maybe Mr. Interlocutor can help out with that. I mean, I would expect that first day is going to be all about jury selection.
I would assume we'll get through a jury on Monday. I would anticipate it would not take me, the state would probably rest by the end of Tuesday, maybe early Wednesday morning, but you know, trials are fluid.
Yep. All right, is there anything else, gentlemen, that we need to address today?
The only thing I have is with the limited number of jurors we have coming in, so 90 total, would there be a way that we can kind of see if we can early on be the first pool to pull jurors, see if we can, with obvious media coverage and leading up to trial, see if we can get rid of any of the ones who have reviewed any kind of the media coverage right out the gate, and that way we can kind of have that 50 be a meaningful 50 as opposed to waiting till the afternoon on the remaining 40.
Yeah, what are your thoughts, Mr. Ferry?
Whatever your thoughts are.
Okay. Yeah, I think that makes sense, and then we can do conflicts like prepaid planned vacations, surgeries, things like that as part of that same initial inquiry to make sure we have a good panel to go through with the further questioning. Yeah, I'm happy to do that.
All right. Thank you, Ari.
Okay. All right, well, thank you, gentlemen. And I'm sorry? No, we don't really need to take a break, but they can go ahead and do what they need to do. I was just, if there's people that need to take pleas, I've got Judge Case in her courtroom in courtroom 1 ready to take pleas. And I saw that we had a couple that might be pleas. I hesitate to ask this question, but is the media here as well for the bond hearing and the Reliant case? I'm gonna regret asking that question.
No,
Okay, good.